Contracts.
Part 2.
Contracts will cover about 12% of your licensing exam. Let's dive in. A contract clause is a section or provision within a contract that addresses a specific point of law or aspect of the agreement. Common contract clauses include choice of law, specifies that any dispute arising under the contract shall be determined in accordance with the law in a particular jurisdiction. Indemnification means one or both parties commit to compensate the other for any harm, liability, or loss arising out of the contract. Contingency clause defines a condition or action that a party must meet in order to not be in breach of contract. An arbitration clause requires the parties to resolve or attempt to resolve their disputes through an arbitration process. A mediation clause requires the parties to attempt mediation prior to engaging in arbitration or legal action. A statute of limitations clause in contracts states the time frame in which a party can file a lawsuit relative to the contract. The California statute of limitations for written contracts is 4 years. Unwritten contracts have a shorter statute of limitations of 2 years. When parties agree to other terms that are outside a main contract, these terms are included in an amendment or an addendum. All these documents together form the complete agreement between the parties. An addendum is an addition to an existing document, such as an offer to purchase. It adds terms not addressed in the main body of the contract's form. An amendment is a change to an existing contract between parties. It changes one or more of the original contract terms. For example, if the closing date must be changed, the parties can execute an amendment. The broker should recommend and/or approve addendum and amendment forms. Remember that addendum is an addition. Add. Amend, change. Listing agreements. Listing agreements are contracts between a licensee and a consumer who become agent and client to sell real property. There is no requirement that the listing agreement be on a specific form. However, to be legally binding, it must be written in clear and unambiguous language, and it must be signed by all parties to the agreement. Common practice is for agents to use pre-printed forms designed by the California Association of Realtors or their local multiple listings service. Licensees must avoid extensive changes or additions to the language on the standard form to avoid the unauthorized practice of law. An exclusive right to sell. An exclusive right to sell agreement is the most commonly used type of listing agreement. This agreement provides the most assurance that the listing agent will receive the agreed-upon commission if the property sells, no matter who procures the buyer. Exclusive agency. Exclusive agency agreements only pay commission to the listing agent if a real estate professional procures the buyer. If the seller procures the buyer, no listing commission is owed. An open listing is a non-exclusive listing. The seller can have open listing agreements in place with multiple licensees. Only the licensee who procures the buyer earns the commission. A net listing is an agreement in which the seller agrees to give the broker all net proceeds above a specified sales price. Net listings are permitted in California, but should be used sparingly, if at all. These listings pose an inherent conflict of interest that could occur if the listing agent fails to present offers that leave little for commission, even though the offers might meet the seller's needs. The pre-printed form for the exclusive right to sell listing agreement is the CAR Residential Listing Agreement. Licensees must have written agreement with a seller to establish the right to a commission. The rate of compensation must not be on a pre-printed form. A provision notifying the seller that commission rate is negotiable and not set by law must be included prior to the clause setting compensation rate. Protection clause designates a time period after the listing agreement expires when the broker is entitled to compensation if a buyer whom the broker procured during the period covered by the agreement makes an offer. Managing brokers must review and initial listing agreements. Listing agreements must specify a termination date. If the clients want to change any terms of the listing agreement after signing, such as extending the listing period or the list price, the agent should use the CAR Modification of Terms form. It is important to have all sellers on the title sign the listing agreement so it is legally enforceable. The CAR Residential Listing Agreement specifies the parties to the agreement, the property for sale, inclusions and exclusions, listing price and terms, and the terms of broker compensation. When a seller wishes to opt out of using the MLS or exclude specific information from the internet, the seller needs to sign additional seller instruction to the broker forms. Using the MLS increases exposure of the property on the market and the potential for the seller to receive top dollar. Listing agents need to be sure their clients understand their options regarding photographs, internet advertising, and key safe lockboxes, and the pros and cons of each. The residential listing agreement clarifies broker and seller responsibilities and duties. The seller and the broker agree to exercise reasonable effort and cooperation in the sale of the property. In the event of a dispute, California law requires that sellers and brokers attempt mediation before taking legal action, regardless of whether the seller and broker agree to this in writing. Provisions of the CAR Residential Listing Agreement address signs, equal housing opportunity, attorney fees, management approval, successors and assigns, and dispute resolution. Buyer-broker agreements, aka buyer representation agreements, establish the agency relationship between a licensee and buyer.
Hey, and while we're here, if you could subscribe, that would be so awesome, and it doesn't cost you anything, so thank you for your support.
Information required on the buyer representation agreement includes the type of property the buyer is seeking, the type of agency relationship that will exist, and what the terms will be for broker compensation. CAR standard forms includes 3 types of buyer representation agreements. Exclusive buyer representation, BRE, which entitles the licensee to compensation when the buyer purchases a property and prohibits the buyer from establishing an agency relationship with another broker. Non-exclusive buyer representation, BRN, which gives the licensee the right to compensation in exchange for showing the buyer properties. It allows the buyer to work with another agent and to compensate only the agent who represents the buyer in the transaction. Non-exclusive, not-for-pay buyer representation, BRNN, which forms an agency relationship that either party can break at any time and doesn't require the buyer to compensate the agent. Since most buyer agents are compensated through a cooperating broker agreement, this allows the buyer to work with an agent without being obligated to pay if that doesn't happen. All 3 types of buyer representations include important advisories as pre-printed addenda to the buyer representation agreement. The agreement allows the buyer to agree to dual agency, which permits the agent to show properties listed with the agent's brokerage, or to agree to single agency only, in which case the agent may not show properties listed with the agent's brokerage. Offers, purchase contracts. Offers to purchase are most often presented on a purchase contract form. Once signed by both parties, the offer becomes a binding contract between the buyer and the seller. Other names for forms used to draft a written sales contract are offer to purchase, sales agreement, contract of purchase and sale, purchase agreement, earnest money agreement, agreement of sale. The sales contract identifies the parties and establishes the transaction's terms and conditions. An agent should request a driver's license, a passport, or some other method of establishing the identity of the parties. Information often included in a sales contract includes the earnest money deposit amount, specific closing instructions, closing agent selection, deed type the seller will present, the proration method for rent, taxes, other closing costs, buyer possession timeline, home warranty transfer, if available, and seller warranty specifics, if offered. Licensees should not determine the amount of earnest money a buyer should give or that a seller should accept. They can discuss what ordinary practice is, but they should allow the parties to determine the amount. The process of the buyer and the seller entering into a contract of sale typically begins when a potential buyer makes a written offer to a seller. Although the form used to make the offer may be called a sales contract, it is not a contract. It's an offer that isn't a contract until the parties come to acceptance. The party extending the offer is the offeror. The party receiving the offer is the offeree. In the event the seller accepts the buyer's offer, there is a contract. In the event the seller does not accept the buyer's offer, the seller will typically extend a counteroffer to the buyer. When this happens, the seller becomes the offerer, and the buyer is the offeree. Acceptance occurs when all parties have signed a contract, while binding acceptance happens when the signed contract is delivered back to the offerer. Acceptance and binding acceptance must take place within the dates outlined in the contract. According to the standard language in the residential purchase agreement, the offer expires if it's not signed by the seller and returned to the buyer within 3 days. If dates aren't specified, they must occur within a reasonable time. Licensees should be careful to use only approved forms for additional terms. Drafting contract language may be considered practicing law without a license. Licensees may fill in the blanks on a sales contract form. It's always a good idea to recommend the client review the sales contract with an attorney before signing it.
And that's it for now. Stay tuned for part 3, baby. Thanks for coming along. Please like and subscribe. Thank you so much. Bye.